Ever had that moment when you're standing on your own property and realize someone's been making decisions about your land without your consent? Not minor decisions like what color you can paint your mailbox, but fundamental decisions about the very land you own. That's exactly what happened to me last spring. What they didn't know was that I've spent my career teaching property law at the university level. And when you bulldoze someone's dock while they're away, you'd better make damn sure you actually have the right to do it. Where are you watching from? Drop a comment below because what you're about to hear isn't just another HOA horror story, it's a masterclass in how property rights work when someone tries to rewrite history. My name's Dr. Robert Hayes, and for the past 12 years, I've been a professor of property law at the university level. I've written textbooks on land rights, water law, and historical property documentation. For the past 8 years, I've lived on a beautiful piece of land on the shores of Lake Watauga in northeastern Tennessee, a place where the mountains meet the water in perfect harmony. I didn't buy this property as an investment. I bought it as a retreat from the academic world, a place where I could apply my knowledge in the real world rather than just teaching it in a classroom. When I first moved to Lakeview Estates, I didn't think much about the HOA. Most lake communities have them, and I figured it was just the usual nonsense about dock placement and boat storage. What I didn't realize was that Lakeview Estates wasn't your average homeowners association. It was run by a woman named Victoria "Vicky" Chambers, who had turned HOA management into a full-time career and a highly profitable one at that. Vicky wasn't your typical HOA president. She wasn't some retiree looking for something to do. She was a former real estate developer who had seen the golden goose of HOA management and decided to cash in. She drove a luxury SUV with HOA Patrol decals, wore designer clothes that cost more than my monthly mortgage payment, and had that particular brand of entitlement that makes you want to check your wallet when she smiles at you. Vicky's specialty was what she called community enhancement initiatives, which was really just a fancy way of saying she'd find any excuse to expand the HOA's territory, increase dues, and fine homeowners for the most ridiculous violations. She'd find a family $500 for having a dock light that was too bright. She'd threaten to put a lien on a widow's home because her rowboat wasn't stored according to HOA specifications. One homeowner was charged $1,000 for excessive algae growth on their portion of the shoreline. Never mind that the algae bloom was caused by runoff from the HOA-maintained common area. What made Vicky particularly dangerous was that she'd married well. Her husband, Charles Chambers, was a county commissioner with significant influence over land use decisions. This meant that when Vicky decided to push through questionable zoning changes or environmental modifications, she had someone in the commissioner's office making sure they happened quickly and quietly. Their power couple status made them virtually untouchable in our community, until they messed with the wrong person. I first noticed something was wrong about 4 months ago. I was returning from a 2-week academic conference in Switzerland when I received a call from my neighbor, Mr. Jenkins. "Rob," he said, his voice shaking, "you need to come home immediately. They've destroyed your dock." When I arrived at my property, I found a scene of complete devastation. My private dock, a structure I'd built myself using materials and methods approved by the Tennessee Department of Environment and Conservation, had been completely bulldozed. In its place was a gaping hole where the dock had once been, with heavy machinery still sitting on my property. I contacted the county sheriff's office and was told that the HOA had filed a safety violation while I was away. According to the paperwork, they'd claimed my dock was structurally unsound and posed a danger to community safety. What they didn't mention was that they'd never conducted a proper inspection, never provided me with written notice of any violations, and had no legal authority to enter my property without my consent. When I confronted Vicky, she smiled that sugary sweet smile she reserves for situations where she knows she's in the wrong but thinks she can talk her way out of it. "Rob, honey," she said, "we're just looking out for everyone's safety. You should be grateful we took care of that dangerous dock for you." Grateful? I was furious. This wasn't about safety. This was about Vicky using her position and connections to expand the HOA's control over private property. I showed her the documentation proving I owned the dock and had followed all proper procedures for its construction. She barely glanced at it before dismissing my concerns with a wave of her hand. "Paperwork can be corrected, Rob. The dock is already gone. Why don't you just accept it and move on?" That's when I knew this wasn't going to be resolved through polite conversation. Vicky operated on the assumption that most people would rather pay the fine or walk away than fight back. She had no idea who she was dealing with. I'm not a confrontational person by nature. I solve problems through data, documentation, and understanding the systems at play. That's what I do for a living. But this was different. This was personal. My property wasn't just my home, it was my life's work in miniature. A place where I'd implemented sustainable shoreline practices that had actually improved the local ecosystem. Vicky's bulldozers weren't just destroying a dock, they were destroying habitat for native species and causing erosion along the shoreline. Most people in my position would have panicked. They would have hired an expensive lawyer and prepared for a long, drawn-out legal battle. But I knew something they didn't. When it comes to property rights in Tennessee, the law is actually on my side, and I knew exactly how to use that to my advantage. Here's what most people don't understand about property. It has history. It carries the weight of past decisions, legal agreements, and historical context. You can't just bulldoze a dock and pretend it never existed. The land remembers, the water remembers, and the legal documents certainly remember. I spent the next 48 hours doing what I do best, gathering data. I checked county records, pulled historical property documentation, and measured the exact dimensions of my shoreline property. What I found was shocking. My property deed included not just the land up to the water's edge, but the entire shoreline along my property line, and, crucially, the lake bed extending 100 feet into the lake. This wasn't just a recent development, it was documented in the original land grant dating back to 1837. The documentation was impeccable. Original land grants, property transfers, and decades of consistent use. But here's the kicker. Vicky's safety violation wasn't just illegal, it was based on a complete misunderstanding of who actually owned the lake. Lake Watauga wasn't a public lake owned by the county or the state. It was a private lake, created by a dam built in 1923 on land that had been in my family since before Tennessee was even a state. I contacted my colleague, Dr. Patricia Pat Reynolds, who specializes in water law at the university. Within an hour, she confirmed what I suspected. The HOA had no authority to enter my property or destroy my dock without proper legal process. "Rob," Pat said, "this isn't just a property dispute. This is a serious violation of property rights. The HOA can't just bulldoze private property because they feel like it. They need proper notice, a hearing, and legal authorization." I knew I had to act fast. The Weather Service was predicting heavy rains in 2 days, which would accelerate the erosion caused by the destroyed dock. But I also knew that rushing into action without proper documentation would play right into Vicky's hands. She'd been waiting for an opportunity to paint me as the unreasonable neighbor who destroyed her property. So I did what any good property law professor would do. I started documenting everything. I set up time-lapse cameras at strategic points along my shoreline. I took detailed measurements of the erosion caused by the bulldozing. I collected water samples to document the changing quality as the shoreline destabilized. I even brought in a drone to capture aerial footage of the entire lake. Then I did something most people wouldn't think to do. I contacted every homeowner in the development whose properties were adjacent to mine. I showed them the historical property records, explained the legal implications, and asked if they'd be willing to sign a petition demanding the HOA respect property rights. What I discovered was both surprising and encouraging. Almost every homeowner I spoke with had their own horror story about Vicky's HOA tyranny. There was Mr. Jenkins, whose property she'd entered without permission to inspect his shoreline. There was Sarah Mitchell, who'd been fined $1,200 for having a native plant garden that didn't conform to HOA standards. There was even a retired judge who'd been threatened with legal action for questioning one of Vicky's unilateral decisions. These weren't isolated incidents. They were part of a pattern of abuse that had been going on for years. And suddenly, everyone was willing to speak up. The fear that had kept them silent for so long was beginning to dissipate, replaced by a shared understanding that Vicky's power only existed as long as people were willing to accept it. While I was building this coalition, Vicky was busy playing the victim. She called an emergency HOA meeting and presented photos of my aggressive behavior near the dock site. She told the gathered homeowners that I was a dangerous individual who was threatening the safety of our community. She even produced a doctored photo that made it look like I was tampering with the dock structure. The local news picked up the story, of course. Vicky made sure of that. She appeared on the evening news wearing a concerned expression and talking about protecting our children from unpredictable neighbors. The reporter didn't bother to verify her claims or check the county records that clearly established my property rights. But here's what she didn't know. I'd been documenting everything from day one. I had time-stamped photos of the dock construction, copies of the county records showing my shoreline ownership, and even video of Vicky admitting that the bulldozing was part of a plan to expand the HOA's common area. I also had detailed engineering reports showing the structural integrity of the dock and the environmental damage caused by its destruction. I also knew something else that Vicky didn't suspect. I'd discovered that her dock destruction wasn't the first time she'd pulled this stunt. A quick search through public records revealed that her previous HOA in North Carolina had paid a $950,000 settlement after a similar incident where they destroyed a homeowner's dock without proper authorization. The details were eerily similar. A safety violation filed while homeowners were away, a hastily executed destruction of private property, and a pattern of intimidation against anyone who questioned her authority. This wasn't just about my dock. This was about stopping a pattern of behavior that had been hurting people for years. Vicky wasn't just a bully. She was a repeat offender who had learned that most people would rather pay the fine or walk away than fight back. The morning after the HOA meeting, I received a letter from Vicky's attorney. It was a cease and desist order demanding that I stop harassing HOA members and spreading false information about the community. It also threatened legal action if I didn't immediately stop my campaign of misinformation. The letter was full of legal jargon designed to intimidate, but it was completely baseless. The kind of thing Vicky's attorney knew would scare most people into silence. Most people would have backed down at this point. But I wasn't most people. I'm a property law professor who spent his career working with historical land documents that have existed for centuries. I know that property rights are written in stone, sometimes literally, and no amount of legal threats can change that. I called Pat again. What happens, I asked, if the county confirms the violations but Vicky refuses to acknowledge my property rights? Pat was quiet for a moment. In that case, she said, you may need to file a quiet title action to establish your ownership of the shoreline and lake bed. But it takes time, usually months. If the erosion continues, you could lose significant property. I knew what she was implying. If the shoreline continued to erode without the stabilizing effect of my dock, I could lose valuable property. And since Vicky had caused the damage by illegally destroying my dock, she, and by extension, the HOA, would be liable for all damages. But there was another option. The county had a process for resolving property disputes that could move faster than a full quiet title action. If I could demonstrate that the HOA had violated clear property rights, I might be able to force Vicky's hand. I spent the next 24 hours studying Tennessee property law. The key was establishing that I owned not just the land up to the water's edge, but the lake bed extending into the lake. In Tennessee, shoreline property owners typically own the land up to the ordinary high water mark. But in this case, the historical documents showed something different. This was it. This was my leverage. I filed a formal complaint with the county property assessor's office, specifically highlighting the HOA's violation of my property rights. I also contacted the Tennessee Department of Environment and Conservation, explaining the situation and emphasizing the environmental damage being caused by the erosion. By noon the next day, I had confirmation that the county would conduct an emergency inspection the following morning. The DNR had also agreed to attend, as had representatives from the county's Environmental Services Department. Vicky couldn't ignore this kind of official attention. Vicky didn't take this news well. That afternoon, she showed up at my door with 2 HOA board members in tow. "Rob," she said, her voice dripping with false concern, "I'm worried about you. You've been acting so erratically lately. Maybe you should take some time to focus on your mental health." I smiled. "That's funny, Vicky. I was just about to suggest the same thing to you." You know, after the county inspection tomorrow morning, you might want to start thinking about your legal liability for that illegal dock destruction of yours. Her face went pale. "You wouldn't dare." "I already did," I said. "The inspection is scheduled for 9 a.m. tomorrow. I suggest you have your attorney there." As she turned to leave, she muttered, "You should have stayed closer to home, Rob." I called after her. "Funny you should say that, because I've been studying property law for 30 years, and I know exactly what happens when you mess with established property rights." The next morning, the county inspection confirmed everything I'd suspected. The HOA had entered private property without permission, destroyed a legally constructed dock, and caused significant environmental damage. The county issued an emergency order requiring the HOA to restore my dock or compensate me for its value within 30 days. Vicky was apoplectic. She demanded to speak to the county director, threatened to sue the inspectors, and even tried to bribe them with offers of future cooperation. None of it worked. The inspectors were professionals who had seen this kind of behavior before. That afternoon, I received another call from Vicky's attorney. This time, it wasn't a cease and desist order. It was a settlement offer, $150,000 to go away and not pursue further action against the HOA. I declined. 2 days later, with the 30-day deadline approaching and no sign that Vicky was going to comply with the county order, I did something that would change everything. I filed a quiet title action with the county court, specifically requesting a determination of my ownership of the shoreline and lake bed. The hearing was scheduled for the next week. I knew what I was doing was risky, but I also knew that sometimes the only way to stop a bully is to stand your ground and force them to face the consequences of their actions. The courtroom was packed the next morning, not just with lawyers and officials, but with homeowners from the community, people who had been silenced by Vicky's tyranny for years but were now ready to speak up. There was Mr. Jenkins, who had kept detailed records of every time Vicky had violated his privacy. There was Sarah Mitchell, who had photographs of her native plant garden before Vicky had forced her to remove it. There was even the retired judge, who had brought a file of legal precedents showing how Vicky had repeatedly overstepped her authority. Vicky arrived with her usual entourage, her husband Charles, 2 high-priced attorneys, and a team of experts who were clearly on her payroll. She was wearing a designer dress in pearls, looking every bit the concerned community leader. But her eyes kept darting around the room, clearly unnerved by the number of people who had shown up to support me. I showed up in my work clothes, khakis and a button-down shirt, the same outfit I wear when I'm teaching property law. Sometimes the best armor is just being comfortable in your own skin. The judge, a no-nonsense woman named Judge Margaret Williams, who had heard hundreds of property disputes in her career, wasted no time getting to the heart of the matter. "Dr. Hayes," she said, "you've alleged that the Lakeview Estates HOA violated your property rights by destroying your dock without authorization. What evidence do you have to support this claim?" I stood up and presented my case methodically. Copies of the county inspection report, historical property records dating back to 1837, documentation of my dock's construction permits, testimonies from neighboring property owners, documentation of Vicky's previous violations in North Carolina, time-lapse footage of the dock destruction, engineering reports showing the dock's structural integrity, detailed erosion maps showing the damage caused by the destruction. Judge Williams reviewed the evidence carefully, her expression growing more serious with each document she examined. Then she turned to Vicky's attorney. "And what does the HOA have to say about these allegations?" The attorney stood up and launched into a well-rehearsed speech about how the dock was a safety hazard and how I was misrepresenting the facts to serve my own agenda. He presented photos of the dock, calling it a danger to the community that needed to be removed for public safety. He even produced a letter from a safety expert who claimed the dock was structurally unsound. Judge Williams listened patiently, then asked a simple question. Did the HOA follow proper procedure before destroying the dock? The attorney hesitated. "Well, Your Honor, we believed there was an imminent safety risk." "Did you follow proper procedure or not?" Judge Williams interrupted. "No, Your Honor," the attorney admitted. "Then why did you destroy private property without following proper procedure?" The attorney launched into a complicated explanation about safety concerns and community welfare. Judge Williams cut him off. "Let me be clear," she said. "This court will not tolerate willful violation of property rights, especially when those violations cause significant damage to private property. The county has determined that the HOA violated proper procedure. The burden is now on the HOA to demonstrate why this violation shouldn't result in significant penalties." She turned to me. "Dr. Hayes, is there anything else you'd like to add?" I stood up and said simply, "Your Honor, this isn't just about a dock. It's about respecting the rule of law. Property rights are the foundation of our legal system. What the HOA has done isn't just illegal, it's disrespectful of the law and the people who depend on it. I'm not asking for special treatment. I'm asking for the law to be enforced, as it should be for everyone." Judge Williams nodded. "The court agrees. The county's findings stand. The HOA must restore the dock or compensate Dr. Hayes for its full value within 30 days. Additionally, the court will consider punitive damages for the willful violation of property rights." As we left the courtroom, Vicky approached me, her face red with anger. "You've ruined everything," she hissed. "The community meeting is tonight, and now this." I looked at her calmly. "You made your choices, Vicky. You decided to break the law and destroy property that wasn't yours. The consequences are on you, not me." That evening, as predicted, Vicky called an emergency community meeting to address the court ruling. She presented a narrative that painted me as the villain, a dangerous individual who was trying to destroy our community. I attended the meeting, armed with copies of the historical property records. When Vicky finished her speech, I stood up and asked if I could address the community. "I've been a member of this community for 8 years," I began. "I've always respected our HOA rules and paid my dues on time. But what happened to my dock wasn't about rules, it was about power. It was about someone believing they could override the law because they had connections." I held up the historical property records. This document, dated 1837, shows that my family has owned not just the land up to the water's edge, but the lake bed extending 100 feet into the lake. Lake Watauga isn't a public lake. It's a private lake created by a dam built on my family's land in 1923. The room went silent as I continued. The HOA has been collecting dues for lake maintenance for years, but they've never had the legal right to manage the lake because they don't own it. The lake belongs to the property owners whose land extends into it, starting with me as the original landowner. I could see the realization dawning on people's faces. Vicky had been collecting dues for lake maintenance for years, but she didn't actually have the authority to do so because she didn't own the lake. The dues you've been paying for lake maintenance, I continued, they should have been going to the actual lake owners, which includes most of you in this room. Instead, they've been going into the HOA's general fund, where they've been used for projects that have nothing to do with the lake. The room erupted in anger. People started sharing their own stories about fines they'd paid for imaginary violations, about dues that had gone up every year without explanation, about Vicky's pattern of abusive behavior. By the end of the meeting, a majority of the homeowners had signed a petition calling for Vicky's removal as HOA president. The aftermath was swift and decisive. The county launched an investigation into the HOA's financial practices. The state attorney general announced a criminal investigation into potential fraud related to the collection of lake maintenance fees. But the most significant development came 2 days later, when I filed a class action lawsuit on behalf of all property owners whose shoreline extended into the lake. The lawsuit sought to recover all lake maintenance fees collected by the HOA over the past 20 years, fees that, according to Tennessee law, should have been going to the actual lake owners. Vicky tried to spin the narrative, of course. She told the local news that the situation was complicated and that I was exaggerating the situation to serve my own agenda. But the evidence was overwhelming. Historical documents proved my ownership of the lake bed. Financial records showed how the HOA had misused lake maintenance fees. And multiple witnesses testified about Vicky's pattern of abusive behavior. Within a week, Vicky had resigned as HOA president. Within a month, she and her husband were facing multiple civil and criminal charges. Within 3 months, the HOA had dissolved completely, replaced by a new homeowners association run by actual homeowners, not power-hungry bureaucrats. The best part? The lake is being managed properly for the first time in decades. The new Homeowners Association has established a lake management committee made up of shoreline property owners. We're implementing sustainable practices to protect the ecosystem, and the community is finally starting to heal from years of Vicky's tyranny. But here's what most people don't realize about situations like this. They're not really about docks or property lines or even HOAs. They're about respect. Respect for the law, respect for history, respect for your neighbors. If you're dealing with an HOA that's overstepping its bounds, here's what you need to do. 1. Know your rights. Get a copy of your property deed and the original development documents. 2. Document everything. Keep detailed records of all interactions and violations. 3. Build alliances. Find other affected homeowners who are willing to stand with you. 4. Go to the authorities. File formal complaints with the appropriate regulatory agencies. 5. Stay calm and professional. Don't let anger cloud your judgment or your strategy. Most HOAs rely on the fact that people don't know their rights and won't fight back. But when you do know your rights and you do fight back, properly and strategically, you'll find that their power evaporates faster than water in the sun. This wasn't about revenge. It was about accountability. It was about making sure that Vicky and her cronies couldn't keep taking advantage of people who didn't know better. And it worked. Not with bulldozers or dramatic destruction, just with knowledge, preparation, and the patience to follow the process. Let me share something I discovered during this process that most people never consider. HOAs operate on the assumption that 95% of homeowners will never read the governing documents. They count on the fact that most people don't know the difference between covenants, conditions, and restrictions, CC&Rs, and the actual development documents that establish the HOA's legal boundaries. When I was reviewing the HOA's financial records during the investigation, I found something astonishing. They had been charging special assessments for projects that had never been approved by the membership. They'd been holding secret meetings where they made decisions that should have required a formal vote. They'd been using funds designated for lake maintenance to pay for Vicky's community relations trips to luxury resorts. The most brazen violation was how they handled the Architectural Review Committee. They'd created a system where any homeowner who questioned an HOA decision would automatically be flagged for special scrutiny on any future renovation requests. It was a textbook case of retaliation, something that's explicitly prohibited under Tennessee law. What really opened my eyes was seeing how the HOA's financial records had been manipulated. They'd created a complex system of shell companies and fake invoices to siphon off money. One company, called Lake Management Services, had billed the HOA over $75,000 in the past year. But when I checked with the Secretary of State's office, I discovered that the company didn't actually exist. It was just a P.O. box and a bank account controlled by Vicky's husband. This kind of financial manipulation is more common than you'd think. A 2022 study by the Community Associations Institute found that nearly 30% of HOAs have some form of financial irregularity, but less than 5% ever face consequences because homeowners don't know what to look for. I want to emphasize something important. This wasn't just about me winning my case. It was about creating a template that other homeowners could follow. After the court ruling, I created a simple checklist for homeowners who suspect their HOA might be overstepping its bounds. I shared it with the other affected homeowners, and within weeks, 3 of them had successfully gotten their dues refunded. Here's what that checklist looks like. 1. Verify your property's inclusion in the HOA. Obtain a copy of your property deed. Get the original development documents from county records. Compare the boundaries in both documents. If they don't match, you may have been improperly included. 2. Review the HOA's governing documents. Request copies of the CCRs, bylaws, and articles of incorporation. Check for proper amendment procedures. Verify that all changes were properly approved. Look for clauses that might have expired. 3. Examine financial records. Request the past 3 years of financial statements. Check for unusual expenses or vendors. Verify that special assessments were properly authorized. Look for patterns of late fees or penalties. 4. Document everything. Keep copies of all communications. Note dates, times, and names of people you speak with. Take photos of any violations you observe. Maintain a detailed timeline of events. 5. Know your state's laws. Research your state's HOA regulations. Understand your rights as a homeowner. Find out which agency oversees HOAs in your state. Learn about the complaint process. The beauty of this approach is that it doesn't require legal expertise. It's about systematic documentation and understanding the rules that govern these organizations. Most HOAs collapse under scrutiny because they're built on a foundation of assumptions. Assumptions that homeowners won't read the documents, won't ask questions, and won't stand up for their rights. I received a message last week from a woman in Chattanooga who used my checklist to challenge her HOA. They'd been charging her $250 a month for lake maintenance on a property that was explicitly excluded from the lake management area in the original development documents. She followed the steps, filed a complaint with the appropriate agency, and within 2 months she'd gotten 2 years of dues refunded and the HOA was under investigation. That's the power of knowledge. That's why I'm sharing this story with you today. One thing I want to address directly is the fear factor. Most people are afraid to challenge their HOA because they're worried about retaliation, higher dues, more fines, or even a lawsuit. I get it. When Vicky first showed up at my door, I felt that same knot in my stomach. But here's what most people don't realize. HOAs are incredibly risk-averse. They're made up of homeowners just like you, and they don't want negative publicity or legal trouble any more than you do. When you approach the situation with documented facts and a clear understanding of the law, you shift the power dynamic. Suddenly, it's not about whether you can afford a lawyer. It's about whether the HOA can afford the negative attention and potential legal consequences of continuing their improper practices. Another common misconception is that you need a lawyer to challenge an HOA. In many cases, you don't. Most states have laws that require HOAs to make their governing documents available to homeowners. The agency that oversees HOAs in your state often provides free resources and guidance. Let me share a story that illustrates this point. After my case was settled, I got a call from a neighbor who had been living in Lakeview Estates for 20 years. She told me that for the past 15 years, she'd been paying $200 a month in HOA dues, believing it was mandatory. When she checked her deed after hearing about my case, she discovered that her property was also explicitly excluded from the HOA. She went to the HOA board meeting and calmly presented her documentation. The board chairman tried to intimidate her, but she stood her ground and cited the specific Tennessee statute that protected her rights. Within a week, she'd gotten all her dues refunded going back 15 years. That's over $36,000. That's the power of knowing your rights. I want to address something else that's important, the emotional toll of these battles. When Vicky first started harassing me, I'll admit I felt isolated. I wondered if I was the only one who saw what was happening. I questioned whether I was overreacting. That's exactly what HOAs count on. They create an environment where questioning authority feels like being a bad neighbor. But here's the truth. Standing up for your rights doesn't make you a bad neighbor. It makes you a responsible community member. A community where people are afraid to question authority isn't a healthy community. It's a community ripe for abuse. When I was preparing for the court hearing, I made a conscious decision not to let anger drive my strategy. Anger makes you sloppy. It makes you emotional. It makes you lose sight of your objectives. Instead, I focused on the facts, the documentation, and the law. I treated the whole process like I would treat a property law case, systematically identifying vulnerabilities and addressing them one by one. This approach served me well in the courtroom. While Vicky's attorney was making dramatic gestures and using emotional language, I was calmly presenting my evidence, citing specific statutes, and letting the facts speak for themselves. The judge responded to that professionalism. Here's something else I learned that might surprise you. Most HOA board members aren't bad people. They're often well-meaning homeowners who've been misled by previous boards or by HOA management companies. The real problem is usually the small group of power-hungry individuals who dominate the board and set the tone for everyone else. In my case, Vicky was the driving force behind the improper dock destruction. The other board members were just going along with it because they trusted her. When the evidence came out in court, several of them looked genuinely shocked. One even approached me afterward to apologize. That's why I always recommend starting with a conversation, not a confrontation. Go to an HOA meeting, ask questions about the governing documents, and request copies of anything you're unsure about. Most of the time, the issue can be resolved with a simple clarification. It's only when you're met with resistance or evasion that you need to escalate. I've heard from dozens of viewers since I started sharing stories like this, and the pattern is always the same. Someone challenges their HOA with documented facts and a clear understanding of the law, and the HOA backs down immediately. They don't want the scrutiny. They don't want the paperwork. They certainly don't want the potential legal consequences. This wasn't about revenge. It was about accountability. It was about making sure that Vicky and her cronies couldn't keep taking advantage of people who didn't know better. And it worked, not with bulldozers or dramatic destruction, just with knowledge, preparation, and the patience to follow the process. Where are you watching from? Drop a comment below and tell me your HOA story. I read every single one. If you're dealing with an HOA that's overstepping its bounds, I'll give you the same advice I'd give a friend. Don't panic, get the documents, know the law, and fight smart. Hit subscribe if you want more stories about taking on bureaucratic bullies and winning. Next week, I'm telling you about the time I took down a corrupt property management company by finding a single missing comma in their contract. That's a story about how the smallest details can bring down the biggest empires. Your voice matters. Your property rights matter. And sometimes all it takes is one person willing to stand up and say, "No more," to change everything. Lake Watauga is managed by its rightful owners now, y'all, and it always will be. Let me tell you more about the historical context of Lake Watauga, because understanding the history is crucial to understanding why Vicky's actions were so egregious. Lake Watauga wasn't always a lake. In fact, it was created in 1923 when my great-grandfather, Robert Hayes Sr., built a dam across Watauga Creek to provide water for his farm and the surrounding community. At that time, the area was primarily agricultural, with farms stretching as far as the eye could see. The dam wasn't just a practical solution, it was a community project. Robert Sr. worked with neighboring farmers to create a reservoir that would provide water during dry spells and help control flooding during heavy rains. The lake that formed behind the dam became a central feature of the community, supporting agriculture, providing recreation, and creating a unique ecosystem. What's important to understand is that when Robert Sr. built the dam, he did so on land that had been in our family since before Tennessee achieved statehood. The original land grant, signed by President James Monroe in 1819, gave my ancestors ownership of 500 acres of land along Watauga Creek. This included not just the land up to the water's edge, but the creek bed itself. When Robert Sr. built the dam in 1923, he created what's known in legal terms as an artificial lake on private property. Under Tennessee law, when you create a lake on your private property, you own both the lake under the lake and the water itself. This is different from natural lakes, which are often subject to different ownership rules. The documentation was crystal clear. The 1923 deed amendment specifically stated, "The property owner shall have exclusive control over the created lake, including but not limited to the water, the lake bed, and the shoreline within the boundaries of the original property." This meant that my family owned not just the shoreline of Lake Watauga, but the entire lake itself. And as subsequent generations divided the property, the ownership of the lake was divided accordingly among the shoreline property owners. When the Lakeview Estates development was created in the 1980s, the original developers understood this arrangement. The development documents specifically stated that lake rights shall remain with the individual property owners whose land extends into the lake. This meant that the HOA had no authority over the lake itself. It could only manage common areas that were explicitly designated as such in the development documents. But somewhere along the way, this understanding got lost, or perhaps deliberately ignored. By the time Vicky took over as HOA president, the narrative had shifted. She began claiming that the HOA owned the lake and had authority over all lake-related matters. She started collecting lake maintenance fees from all homeowners, not just those with lakefront property. She began enforcing rules about dock construction, boat storage, and shoreline modifications that had no basis in the actual governing documents. What made Vicky's actions particularly egregious was that she wasn't just overstepping her authority, she was actively erasing history. She had the original development documents altered to remove references to individual lake ownership. She pressured the county assessor's office to change property classifications. She even went so far as to file false claims with the Tennessee Department of Environment and Conservation, claiming that the HOA owned the lake and had authority over all lake-related matters. This wasn't just bureaucratic overreach, it was a systematic effort to rewrite history and seize control of property that didn't belong to her. When I discovered this during my research, I knew I had to go deeper. I spent weeks at the county archives, digging through old property records, development documents, and historical maps. What I found was a paper trail that documented the gradual erosion of individual lake ownership rights. In the 1990s, the HOA began charging lake maintenance fees to all homeowners, not just those with lakefront property. In the early 2000s, they started enforcing rules about dock construction that had no basis in the governing documents. By the time Vicky took over in 2015, the HOA was claiming complete authority over the lake despite having no legal basis for that claim. The most damning evidence I found was a series of internal HOA memos from 2017, in which Vicky explicitly discussed the need to consolidate lake control and minimize individual property owner claims. In one memo, she wrote, "As long as individual homeowners believe they have rights to the lake, we'll never be able to maximize its value for the community." This wasn't just about control, it was about profit. Vicky and her husband Charles saw the lake as a revenue stream. By claiming authority over the lake, they could charge higher dues, impose fines for violations, and even sell lakefront property at a premium. What they didn't count on was someone who actually knew the history and was willing to fight for it. When I presented this historical evidence in court, it was a game changer. Judge Williams was visibly shocked by the extent of the HOA's deception. "This isn't just a property dispute," she said. "This is a deliberate effort to erase history and seize control of property that doesn't belong to the HOA." The historical evidence also helped me build a stronger case for the class action lawsuit. If Vicky and the HOA had been collecting lake maintenance fees from homeowners who didn't actually have lakefront property, those fees were unjust enrichment. And if they had been imposing fines for violations of rules that had no legal basis, those fines were illegal. The more I dug, the more I realized how widespread the problem was. I discovered that similar situations existed in lake communities across Tennessee. HOAs were claiming authority over lakes they didn't own, charging fees they had no right to collect, and imposing rules that had no legal basis. This wasn't just about my dock, it was about a systemic problem that was affecting homeowners across the state. I decided to take my fight beyond the courtroom. I reached out to state legislators who specialized in property rights. I met with the Tennessee Department of Commerce and Insurance, which oversees HOAs in the state. I even spoke at a conference of property law professors about the importance of preserving historical property rights. The result was HB 1732, a bill that was introduced in the Tennessee legislature to clarify lake ownership rights and prevent HOAs from claiming authority over lakes they don't own. The bill, which I helped draft, would require HOAs to provide clear documentation of their authority over any water bodies they claim to manage. It would also establish penalties for HOAs that falsely claim authority over lakes or other water bodies. The bill faced strong opposition from HOA industry groups, but it gained widespread support from homeowner advocacy organizations. After months of hearings and debate, it passed the Tennessee House of Representatives with a vote of 78-12. When Governor Lee signed the bill into law, it represented a major victory, not just for me, but for homeowners across Tennessee. The law, now known as the Lake Ownership Protection Act, has already prevented similar situations from occurring in other communities. But the fight wasn't over. I knew that changing the law was only the first step. The real challenge was making sure homeowners knew their rights and were empowered to defend them. That's why I started the Lake Rights Project, a nonprofit organization dedicated to educating homeowners about their property rights, particularly as they relate to lakes and other water bodies. Through the project, we offer free workshops, publish educational materials, and provide legal assistance to homeowners facing HOA overreach. We've already helped hundreds of homeowners across Tennessee understand and assert their rights. We've recovered millions of dollars in improperly collected fees. And we've helped communities establish fair, transparent systems for managing lakes that respect individual property rights. One of the most rewarding aspects of this work has been seeing how it has transformed communities. In places where there was once fear and mistrust, there is now cooperation and mutual respect. Homeowners who were afraid to speak up are now actively participating in community decisions. And lakes that were once sources of conflict are now sources of community pride. I've also been working with historians to document the true history of Lake Watauga and other artificial lakes in Tennessee. We're creating digital archives that preserve historical documents, photographs, and oral histories. These archives serve as both a historical record and a resource for homeowners who need to understand their rights. One of the most fascinating discoveries we made was a series of letters written by my great-grandfather, Robert Sr., in the 1920s. In these letters, he described his vision for the lake he was creating. "I don't see this as just a reservoir for my farm," he wrote. "I see it as a community resource that will bring people together and provide for generations to come. But I also believe that those who live along its shores should have a say in how it's managed." This vision that the lake should be a community resource while respecting individual property rights had been lost over the years. But thanks to our efforts, it's being restored. The Lake Rights Project has also expanded beyond Tennessee. We're working with homeowner advocacy groups in other states to address similar issues. What we've learned in Tennessee is applicable to lake communities across the country. One of the key lessons we've learned is that property rights aren't just legal concepts, they're part of our community identity. When we respect property rights, we create communities where people feel invested and valued. When we ignore or violate property rights, we create communities where fear and mistrust prevail. This is why what happened with my dock was so important. It wasn't just about a piece of wood extending into the water. It was about respecting the history, the law, and the community that has grown up around Lake Watauga. Today, Lake Watauga is managed through a cooperative system that respects both individual property rights and community needs. The new Homeowners Association has established a lake management committee made up of shoreline property owners. This committee works with all homeowners to establish fair, transparent rules for lake use. We've implemented sustainable practices to protect the ecosystem, including native plant restoration along the shoreline and fish habitat improvement projects. We've created a system for shared dock maintenance that ensures everyone has access to the lake while respecting individual property rights. Most importantly, we've created a culture of respect and cooperation. Homeowners feel empowered to speak up and participate in community decisions. Disagreements are resolved through dialogue rather than intimidation. And the lake, which was once a source of conflict, is now a source of community pride. This transformation didn't happen overnight. It took time, patience, and a commitment to doing what was right. But it was worth it. If you're dealing with a similar situation in your community, I want you to know that you're not alone. There are resources available to help you understand and assert your rights. There are people who have been through this before and are willing to help. And most importantly, there is hope. The Lake Rights Project offers free resources on our website, including guides to understanding your property rights, templates for challenging HOA overreach, and a directory of attorneys who specialize in property law. We also offer free workshops and consultations for homeowners facing HOA disputes. Remember, property rights are not just legal concepts, they're the foundation of our communities. When we respect property rights, we create communities where people feel invested and valued. When we ignore or violate property rights, we create communities where fear and mistrust prevail. This is why it's so important to stand up for your rights, not just for yourself, but for your community and for future generations. Lake Watauga is more than just a body of water. It's a community resource, a historical landmark, and a symbol of what can be achieved when we respect property rights and work together. And it's finally being managed the way it should have been all along. Let me share with you some practical advice for dealing with HOA disputes based on everything I've learned through this experience. First and foremost, know your documents. Most HOA disputes arise because homeowners don't understand what their HOA actually has authority over. Get copies of all your governing documents, the Declaration of Covenants, Conditions, and Restrictions, CCNRs, the bylaws, and the Articles of Incorporation. Read them carefully. Pay particular attention to sections about property boundaries, common areas, and the HOA's authority. If you're unsure about something, don't hesitate to ask for clarification. Most states have laws requiring HOAs to provide copies of governing documents to homeowners upon request. If your HOA refuses to provide these documents, that's a red flag. Second, document everything. Keep a detailed record of all interactions with your HOA, meetings, emails, letters, even casual conversations. Note the date, time, location, and names of everyone involved. Take photos of any violations or issues you observe. If possible, get witness statements from other homeowners who can corroborate your account. Documentation is crucial because HOA disputes often come down to he said, she said situations. Having a detailed record of events can make the difference between winning and losing your case. Third, understand your state's laws. HOA regulations vary significantly from state to state. Some states have strong protections for homeowners, while others give HOAs broad authority. Find out which agency oversees HOAs in your state, usually the Department of Commerce or Insurance, and familiarize yourself with the relevant laws and regulations. Fourth, build alliances. Most HOAs rely on the fact that homeowners act individually rather than collectively. If you're facing an issue, chances are other homeowners are facing similar issues. Reach out to your neighbors and see if they're willing to work together. There's strength in numbers. Fifth, know when to seek professional help. While many HOA disputes can be resolved without legal assistance, some situations require professional expertise. If you're facing significant fines, potential liens on your property, or other serious consequences, consider consulting with an attorney who specializes in HOA law. Sixth, stay calm and professional. It's easy to get emotional in these situations, but anger and aggression will only hurt your case. Approach the situation with a clear head and a focus on facts rather than emotions. Be respectful in all your communications, even when others aren't. Seventh, understand the complaint process. Most states have procedures for filing formal complaints against HOAs. These processes are often faster and less expensive than going to court. Find out how to file a complaint in your state and follow the proper procedure. Eighth, know your options for dispute resolution. Many states require HOAs to offer mediation or arbitration before escalating to court. These alternative dispute resolution methods can be effective and are usually less expensive than litigation. Ninth, be persistent. HOA disputes can be lengthy and frustrating. Don't give up after the first setback. Keep documenting, keep communicating, and keep pushing for a resolution. 10th, remember that you're not alone. There are many resources available to help homeowners dealing with HOA disputes. The Community Associations Institute, the National Association of Home Builders, and various homeowner advocacy groups all offer resources and support. One thing I've learned through this experience is that most HOA board members aren't bad people. They're often well-meaning homeowners who've been misled by previous boards or by HOA management companies. The real problem is usually a small group of power-hungry individuals who dominate the board and set the tone for everyone else. When dealing with an HOA board, try to separate the individuals from the institution. Focus on the facts and the law, not personal attacks. Build relationships with board members who seem reasonable and open to dialogue. And remember that most board members are volunteers who are trying to do what they think is best for the community. Another important lesson is that prevention is better than cure. If you're considering buying property in an HOA community, do your homework before you buy. Read the governing documents carefully. Talk to current homeowners about their experiences. Find out if there have been any significant disputes or legal issues. If you're already living in an HOA community, stay involved. Attend board meetings, volunteer for committees, get to know your neighbors. The more involved you are in your community, the less likely you are to face problems down the road. I've also learned that education is key. Most HOA disputes arise from misunderstandings about what the HOA can and cannot do. By educating yourself and others about property rights and HOA regulations, you can prevent many disputes before they happen. That's why I created the Homeowner's Guide to Property Rights, a free resource that explains the basics of HOA law in plain language. The guide covers topics like understanding your governing documents, knowing your rights as a homeowner, and resolving disputes with your HOA. The guide has been downloaded thousands of times and has helped homeowners across the country understand and assert their rights. It's just one example of how education can make a difference. Another resource I've found helpful is the HOA Scorecard, a tool that helps homeowners evaluate their HOA's performance. The scorecard looks at factors like financial transparency, communication, dispute resolution, and respect for property rights. By using the scorecard, homeowners can identify potential problems before they become serious issues. I've also worked with local universities to develop workshops on property rights for homeowners. These workshops cover everything from understanding your deed to challenging HOA overreach. They're designed to be accessible to everyone, regardless of legal knowledge. One of the most important things I've learned is that change is possible. When I started this journey, I felt like I was fighting a losing battle. But with persistence, knowledge, and community support, I was able to make a real difference, not just for myself, but for my entire community. And that's the most important lesson of all. You have the power to make a difference. It might not be easy, and it might not happen overnight, but with the right approach, you can stand up for your rights and create positive change in your community. So if you're dealing with an HOA dispute, don't give up. Get the documents, know the law, build alliances, and remember that you're not alone. Lake Watauga is a testament to what's possible when homeowners stand together and fight for their rights. And it's a reminder that property rights aren't just legal concepts, they're the foundation of our communities. As I sit on my new dock watching the sunset over Lake Watauga, I'm reminded of why this fight was worth it. The water is clear, the shoreline is healthy, and the community is thriving. It's everything my great-grandfather envisioned when he built the dam nearly a century ago. And it's a reminder that sometimes the best way to honor the past is to fight for the future. Where are you watching from? Drop a comment below and tell me your HOA story. I read every single one. If you're dealing with an HOA that's overstepping its bounds, I'll give you the same advice I'd give a friend. Don't panic. Get the documents, know the law, and fight smart. Hit subscribe if you want more stories about taking on bureaucratic bullies and winning. Next week, I'm telling you about the time I took down a corrupt property management company by finding a single missing comma in their contract. That's a story about how the smallest details can bring down the biggest empires. Your voice matters, your property rights matter, and sometimes all it takes is one person willing to stand up and say, "No more," to change everything. Lake Watauga flows free, y'all, and it always will.